Welcome. In this lesson, we'll be focusing on the subject of adverse inferences, specifically Section 34, subsections 1 and 2 of the Criminal Justice and Public Order Act 1994. Section 34 allows an adverse inference to be drawn if a suspect is silent when questioned under caution prior to charge or when charged, and subsequently relies upon a relevant fact at court, which he or she could reasonably have been expected to mention when questioned. Just because a suspect declines to answer questions, it does not automatically mean that an adverse inference can be drawn. A suspect is under no obligation to answer questions before or after charge. He does have a right to silence. It is only when he later seeks to put forward an account or explanation at trial that the adverse inference provision is triggered. I'd like you to meet Sammy.
You do not have to say anything, but it may harm your defence if you do not mention, when questioned, something which you later rely on in court. Anything you do say may be given in evidence.
I have advised my client to answer no comment to all questions.
That's right. You've been arrested in relation to a burglary that occurred at 2 a.m. on Saturday the 16th of November. Now, where were you? I'm saying nothing.
Please assume Sammy refused to answer any questions about the burglary. He was subsequently charged with the offence. He failed to make any comment when charged. During Sammy's trial, he did not give evidence, nor did he call any witnesses. Could adverse inferences be drawn? No. Section 34 does not apply when an accused simply fails to answer questions in interview. However, if Sammy's barrister had put a positive case to prosecution witnesses when cross-examining them, for example, by suggesting that Sammy was elsewhere when the offence was committed, Section 34 would be engaged.
The defendant was elsewhere at the time of the burglary.
Similarly, if witnesses called on behalf of the defence gave evidence that Sammy was at home with his girlfriend when the offence was committed, Section 34 would also be engaged. Assume Sammy decides to give evidence. In examination in chief, he explains that he did not commit the burglary and that in fact, at the time of the burglary, he was at home watching TV with his girlfriend, Samantha. Could an adverse inference be drawn in this situation? Yes, absolutely. The defendant failed to mention the alibi when he was interviewed or when charged. He is now relying on the fact of an alibi in his defence. This is something that he could reasonably have been expected to mention when he was interviewed about the offence or when he was charged. Let's assume that Sammy is being cross-examined by the prosecution advocate. The advocate questions him about his failure to mention being at home with Samantha.
You didn't mention you were at home with your girlfriend when you were interviewed about the burglary.
My solicitor told me to go no comment.
Will that explanation avoid an adverse inference being drawn? Probably not. If Sammy wants to avoid adverse inferences being drawn, he will need to explain the basis or reason for the advice given by his solicitor. But if Sammy explains why he was advised not to answer questions in interview, there will be serious consequences. He will be deemed to have waived legal professional privilege. This will allow the prosecution to cross-examine Sammy or Sammy's solicitor about the reason for the advice.